My name is Sandra Vargas Tinoco. I am the Assistant Director for International Faculty and Scholar Services here at the International Services and Engagement Office, or ISCO. I'd like to thank you all for joining us today. I would like to start by asking you all to please keep questions general and related to today's topic. You can enter your questions in the Q&A box that's located at the bottom. Please avoid case-specific inquiries. If you do have case-specific inquiries, make sure you reach out to your ISEO advisor. Just know that our office is planning to host additional sessions on current immigration updates at a later time, so that's where some of your questions might be addressed. So I am pleased to introduce Diana Vellos Coker from Larrabee, Albee and Coker, located here in San Diego. We're fortunate to have her here today to present on U.S. immigration and employment options for our international students and scholars. We hope this session will help you better understand your visa pathways and plan for your future. Thank you for being here. And thank you, Diana.
Absolutely. Thank you so much, Sandra, for that introduction. Really enjoying being here, talking about immigration. There's a lot going on. Today, we want to focus on employment-based immigration options. And like I said, definitely want to make sure that all of our questions get answered. So we'll do our best to save some time at the end. A lot of material to go through, but want to make sure that we cover all of the key options. So I'm going to share my screen and see if we can get started here. All right, hopefully everyone can see that screen. As I mentioned, we are going to be focusing on employment-based immigration options. And so just to give you an overview, some of the categories that we want to cover today are the H-1B cap lottery system, also the H-1B exempt employers, also touch on F1 students and the OPT and the STEM OPT options. And then we will also hit upon the O1 temporary visa option for individuals of extraordinary ability. Then we'll transition to the green card pathways. We have a few that we want to touch upon, including the employment-based first preference options, which include outstanding researchers and individuals of extraordinary ability. And then going into the employment-based second preference category, national interest waivers, and then also touching on the labor certification process. So lots of material to cover, but definitely important information. So let's start with the H-1B. The H-1B is a temporary work visa option. It is probably the most popular work visa. And it is for individuals that qualify as working in specialty occupations. So the question becomes, what is a specialty occupation? And that is a position which requires at least a bachelor's degree in a specific area in order to perform the job duties. So if the job doesn't require a degree or it requires a degree in any field, it's not going to qualify. But if the position is one which requires a degree in computer science, computer engineering, etc., we can make the argument that it's a specialty occupation. We also then need to show that the individual has that degree or its equivalent. And so the equivalent can be a foreign degree that is evaluated as the equivalent to a US bachelor's degree. It also can be a combination of academics and work experience or pure work experience that has been evaluated as the equivalent to the bachelor's degree in that specific field. The H-1B also requires that the employer pay the prevailing wage for the position and that the employer file and get certified a labor condition application, which is submitted to the Department of Labor, essentially confirming that they are willing to pay the prevailing wage and that they understand the regulatory parameters of the H-1B. I like to stress that the H-1B is employer specific, job specific, location specific. So if any of those things change, it could require that an H-1B amendment needs to be filed, or an H-1B change of employer petition if you're changing employers. So I always like to stress that point because individuals say, I have an H-1B, can I work on the side? Can I do something extra? And the H-1B only allows you to work for that particular employer at that particular location doing that particular job. All right, the last point regarding general H-1B information is that normally there is a 6-year limit on H-1B time. And normally the H-1B is issued for 3 years, and then we extend for an additional 3. Now, the H-1B can be extended beyond that 6-year limit if the individual is at a particular point in their green card process. But if there is no green card process which would qualify them for additional extensions, we're looking at just that 6-year period of time. All right, so let's talk about how do we get this H-1B. So normally there is a lottery process, and there are more companies and individuals trying to secure H-1Bs than there are numbers available. Each fiscal year, a new allotment of H-1Bs are released. And so we have 58,200 what we consider regular H-1Bs. And then we have an additional 20,000 H-1B numbers that are set aside for individuals with U.S. master's degrees. So if you have a foreign master's, that's not going to qualify for that additional allotment. It's U.S. master's degrees. So individuals that have U.S. master's degrees or higher, they have access to more numbers. And normally what happens is they run the master's cap lottery first. Whoever is not selected then drops down to the regular cap, and they run that lottery at that point. Just to give you an idea, last year, there were 343,981 registrations for this limited number of H-1Bs. So it really is a lottery in the true sense of the word. Some changes are anticipated for the lottery this year. And that is this $100,000 fee for certain petitions. So you probably saw this in the news. It's obviously getting a lot of attention. So let's talk about this for a little bit. The $100,000 fee applies to brand new H-1B petitions for individuals who are outside of the United States at the time the H-1B is submitted. It does not apply to individuals who are inside the United States seeking to change their status to H-1B, and that petition is approved. So in that scenario, you're an F, you're a J, and you are changing your status inside the United States to H-1B, the $100,000 would not apply. If you are abroad sitting in India or France or China, and you're trying to get an H-1B number to come into the United States, the $100,000 fee would apply. Now, If you are, there's one exception here that's important to note. If you're doing a change of status, you say, I'm here in the US, I want to change my status to H-1B. I won a lottery, so I can file this H-1B petition. There is a provision that says, look, if the Immigration Service determines that you are not properly maintaining your status, you were an F, but maybe you worked without authorization, or you dropped out of your classes, or something to make you not maintain status. In that scenario, they would approve the H-1B petition for you to complete the process at the consulate, and then that $100,000 fee would apply. So if you're in the US, you are maintaining your status, you can change status to H-1B, no $100,000 fee. That's the big takeaway. There were some questions about, well, what if I later travel and I'm outside the US? Will that trigger the fee? And we've gotten clarification. The answer is no. If the case is approved with you inside the United States, any subsequent travel is not going to trigger that fee. All right. So let's say you are outside of the US and that $100,000 fee applies. There is a way to request an exception so that the employer does not have to pay that $100,000 fee. And that is if it is in the national interest. It's a national interest exception. We have been told that that's going to be very rare. So we will see. Now, that is a change that's definitely going into effect. We also have a proposed change. We will see if this goes into effect. We believe it will. And that is a wage-based lottery system. This is going to be completely new. And basically, what they're going to do is they're going to look at the wage level that the employer is going to use for prevailing wage purposes. And they will then see if, according to the government wages, if it's a level 1, level 2, or level 3, level 4 wage. There's 4 wage levels. If the employer is paying a level 4 wage level, the person will get 4 entries into the lottery system. Level 3, 3 entries into the lottery system. Wage level 2 gets 2 entries, level 1 gets 1 entry. So in the past, people would always ask me, what can they do to improve their chances in the lottery? And I'd always say, get a US master's degree. But now we also have this other way to improve your chances, and that is the employer pays a higher wage, you get more entries into the lottery system. Again, we'll need to see if this actually goes into effect. We believe it will, but I wanted to definitely discuss it. All right, so this lottery that I just spoke about, let's talk about some details. Normally, it's in the first few weeks of March. They will announce the window. It's normally 2 weeks that we have to submit the registrations. Then they normally issue the first round of selections the end of March, and there is a 90-day window for employers to then file petitions with the Immigration Service. Now, in prior years, there were additional selection rounds. We will need to see if that happens. The last point I want to make is something called cap gap. So F1 students often will have OPT, optional practical training work authorization, for a set period of time. And so the question becomes, what if their OPT expires before the H-1B takes effect? The H-1B, even though we file the registrations in March, the H-1B cannot take effect until October 1st. And so the Immigration Service says, we have this cap gap provision, which if your work authorization expires in between the time you file the H-1B petition until the H-1B is going into effect, you can be covered by CAP-GAP. Your F-1 work authorization is extended. So that's something to obviously keep in mind. It's a nice benefit. Now, as I mentioned, when I showed you the numbers of how many people register and how many numbers are available, we really are looking at, between a 20 and 30% selection rate. And so many people ask, is there a way to get around going through this lottery? And there is. The workaround is to work for an employer who is not subject to the lottery system. And so certain employers are considered exempt from the lottery. So who are these employers? They fall into four categories. They are institutes of higher education that are basically nonprofit colleges or universities. So you want to work for UCSD, you are not going to be subject to the lottery system. The next group are nonprofit organizations that are affiliated with an institute of higher education. So, for example, many hospitals will have an affiliation agreement with a university to train, let's say, nurses or other healthcare professionals. That could be a way to get an H-1B number with an H-1B exempt employer. The two other categories are nonprofit research organizations and government research organizations. So those are employers that can file an H-1B petition at any time. They don't have to wait for a particular window to file. They don't have to worry about if there are numbers available. They are able to file at any point. Now, the issue though is they can still be subject to the $100,000 fee if the individual is outside of the United States. So that requirement does not go away. Okay. All right, let's transition to F1 students. F1 students have something called optional practical training. And so just wanted to touch on the two types of optional practical training that we see. The first one is what we consider regular optional practical training. Students may request up to 12 months of optional practical training after graduation. The school DSO, designated student official, has to authorize that OPT employment. Then the student applies for an EAD, employment authorization document, with the Immigration Service, USCIS. And then once that work authorization card is in hand, they can begin work. You must complete that OPT process requesting that. You must complete the OPT within a 14-month period after graduation. Individuals are eligible for 12 months of OPT at each degree level. So you get a bachelor's here on an F1, you get 12 months. If you then, after that, go for a master's, you can get another 12 months, PhD, another 12 months. If you have a master's, you have your OPT, you decide to get a second master's degree, no additional OPT period, okay, because that's the same degree level. Now we have something also called a STEM extension for OPT. This allows students an additional 24 months of work authorization, but it is only available if you have a STEM degree, so science, technology, engineering, mathematics degree, and you are working for an E-Verify employer. So E-Verify is a program that employers can voluntarily sign up for, which runs all of their new hires through a work authorization verification system. So the employer has to be an E-Verify employer. You also need to complete a training program to say what is going to be accomplished over those 24 months, who is going to be supervising, how is the work going to be assessed. So there definitely has to be a correlation between what you are studying and the work that you are going to be doing. All right, let's focus on another temporary work visa category, and that is the O1 visa. If you've noticed, we've kind of dealt with lots of letters of the alphabet. We had H, we had F, now we have O. I like to think about the temporary work visas as kind of an alphabet soup. We actually start with the letter A, and we have visa types all the way through the letter V. And each letter of the alphabet, that particular visa serves a particular purpose. So the O visa is for individuals of extraordinary ability. And that extraordinary ability can be in the sciences, in the arts, in education, in business, or athletics. So it's pretty broad. But you have to show that you are really at the top of your field. So again, we have this definition, one of a small percentage of persons who have risen to the very top. So we always like to think of it as kind of like the creme de la creme, who's coming up to the top. And so if you feel you are at that level, the way that we prove that somebody is eligible for the O1 is that they have to meet 3 evidentiary criteria. So we have a list and we have to meet 3 of them. And the list contains things like publications, judging the work of others, original contributions that have impacted the field, serving in a critical capacity for an organization with a distinguished reputation, commanding a high salary, being a member of an organization which requires extraordinary accomplishments in order to be a member. But I think the important thing to keep in mind with these criteria is that this is extremely discretionary. So you might say, I have 2 publications, so that should meet that category. But the officer who receives the case, they're going to take a look and they're going to determine, are 2 publications sufficient to show that this person has met this criteria, or do I want to see more? And each officer can make that determination. So we can't say hard and fast, you need to have X, Y, and Z in order to get this approved. We can give you guidance and say, on average, this has been successful, but you may get an officer who is more stringent, or you may have an officer who is more generous with their adjudications. So just to understand that there is that discretionary factor. And then here's the other point. Even when you meet the 3 evidentiary criteria, there is a second analysis that happens, and the officer has to then take a step back and say, in the totality, do I feel like this person is extraordinary? And so you can actually have cases where the person has the 3 categories, but the officer says, I'm not going to approve this because in the totality, I don't feel this person is extraordinary. All right, just a little bit of a few odds and ends here with the O. It can be issued up to 3 years, and it can be then extended in 1-year increments. And that extension can be, you can keep doing it as long as the need is there for the work that you are performing. So there's no max out for the O1. All right. let's transition to the green card process. So the visas we were talking about were temporary visas, but we also have various green card options for permanent residents. And the way that our employment-based immigration system is set up is we have preference categories. I kind of like to think of it as like a pyramid. And so at the top of the pyramid, we have the EB1 category, employment-based first preference, and that covers individuals of extraordinary ability, individuals who are outstanding researchers or professors, and multinational managers. And then we drop down, we have the employment-based second preference category, and that is for individuals whose work is in the national interest of the United States. And we have labor certification-based processes where the position being applied for requires at least a master's degree or a bachelor's degree and 5 years of experience. So we call those cases advanced degree professional cases. So that falls within the EB2 category. Then we drop down to EB3, employment-based third preference, and those are labor certification processes where the position requires at least a bachelor's degree or 2 years of work experience. And so we'll talk a little bit about each of these. But before we do, let me explain why it's important. Why do you care if it's EB1, EB2, EB3? Well, just like the H-1Bs, where we only had a certain number of H-1Bs each year, for the employment-based green card process, we only have a certain number of green cards that can be issued each year. And so the way they've decided to give out these green card numbers is based on your preference category and your country of birth. And so the higher the category, the less time you may have to wait for a green card number to become available. And as crazy as this sounds, the way the system is created, each country gets the same allotment of green card numbers. So China or India gets the same number of green cards as Switzerland or Guatemala. And so as you can imagine, there are tremendous waiting lines for people who were born in India or China because there are more people coming than there are green card numbers available. And so where you are in the preference category and your country of birth are going to dictate how long this process takes for you. All right. So let's talk about the employment-based first preference. And the first category is extraordinary ability. So this is the green card corollary to the O1. And so you must demonstrate extraordinary ability, again, in the sciences, arts, education, business, or athletics through sustained national or international acclaim. And so to do that, you have to meet 3 of the evidentiary criteria, or you can provide evidence of a one-time major achievement. You won the Pulitzer, you won the Nobel Prize, you got an Oscar, you got an Olympic medal, etc. Most people don't have that one-time major prize. So many times we're looking at trying to satisfy the 3 criteria. And the criteria are very much the same as in the O1 category. And again, it is discretionary. And what we have found is that the standard of review, the level of scrutiny is higher for the green card extraordinary ability than it is for the O1. So you could have gotten an O1 and not necessarily be successful with an EB1 extraordinary ability green card case. All right. Um, the one nice thing with this EB1 extraordinary ability is you do not need to have an employer sponsor you. You can self-sponsor. The idea is if you are so extraordinary, we don't care if you have an employer willing to hire you. We need you here so that you can do your extraordinary work. You also don't have to go through the labor certification process, which means there is no testing of the local job market for your position. You're extraordinary. We need extraordinary people here in the United States. That is the logic. The next category is for outstanding professors or outstanding researchers. And so for this one, you have to demonstrate international recognition for your achievements in a particular academic field. So how do we do that? You have to have at least 3 years of experience teaching or in research for that particular area. You have to be coming to the United States to pursue a tenure or a tenure track position. Or if you're working for private industry or a private employer, a research position, it has to be kind of a permanent level role. What's interesting here, though, instead of having to meet 3 criteria, like for extraordinary ability, we only need to meet 2 criteria. The criteria are a little different, but the main ideas are still there. Original contributions to the field, publications, awards, judging the work of others, things like that. Now, if you are having a private employer sponsor this, there is an additional requirement that the employer needs to show a track record of accomplishments and that they employ at least 3 full-time researchers. So universities, for professors, so forth, they don't need to prove that, but for private employers, we do. So this category requires an employer to sponsor. You cannot self-sponsor. It also is a very discretionary category. Okay, so now we have the national interest waiver. Now that is the employment-based second preference. So we're now going down in the pyramid. And this is for individuals whose work is in the national interest of the United States. And so the first thing we need to show is that the individual either has an advanced degree, so master's, PhD, medical doctor, etc., or that they are a person of exceptional ability, and they give us some guidelines on how to show somebody has exceptional ability. Once we satisfy that, then we have to show that the person can meet 3 prongs of this national interest waiver. The first prong is that your endeavor has substantial merit and national importance. And so there's lots of case law around this particular point. And they have said, for example, if you are a teacher, you teach high school, and there's obviously substantial merit in educating our youth. But what they say is that that does not have a national impact. It has a local impact. So we have to show the national importance of what you are doing. We also need to show that you are well positioned to advance that particular endeavor. So what have you already accomplished? What kind of degrees do you have? What kind of awards have you received? How can we show that you are well positioned to advance this particular endeavor, which is in the national interest of the United States. And then the third prong is that on balance, it is more beneficial to the United States to waive the job offer requirement and a testing of the US local job market. It's more beneficial to have you here than to go through that process. And so obviously that can be tricky to show, but you have to, again, kind of go through how important the work you are doing is and what kind of impact you will have nationally on the field for them to say, okay, it is more important for us to approve this than it is to have this person go through the normal regulatory channels to get a green card. The one thing I will say about the national interest waiver is that this, like many other visa categories, we see adjudications kind of change over time. I like to think of it as like a pendulum that kind of swings one way and then it kind of swings the other way. So there was a period of time when national interest waivers were getting approved like crazy. And I can tell you that that has stopped. We are seeing much more scrutiny and harsher decisions with the national interest waiver. The nice thing, though, with the national interest waiver is, again, you do not require a US job offer. An employer does not need to sponsor you. You can self-sponsor. And you don't have to go through a testing of the local job market. So those are some nice benefits. But again, you are going to be in that employment-based second preference category. All right, transitioning down to the labor certification process. So the labor certification process can either be employment-based second preference or employment-based third preference. It'll depend on the minimum requirements for the position. That's going to dictate whether it's second preference or third preference. This is an employer-sponsored process. And so with the labor certification process, the employer tests the local job market to see if there are any interested or qualified US workers. And if they can show that there are not any interested or qualified US workers, the labor certification can be filed with Department of Labor. So this is a Department of Labor process. The employer recruits for the position using the minimum requirements for the position. So in the real world, employers are always looking for the best candidate. Who is the best person I can find for the job? That's really not what we're doing here. What we're doing is saying, what are the core minimum job duties that somebody must be able to perform in order to do this job? And, you know, while the foreign national employee may be head and tail above any other applicant, if the applicants can meet the minimums, that is enough for us not to be able to proceed with this. So we need to show that there are no US workers that can do this job based on the minimum requirements. The employer has to go through very specific recruitment activities that the Department of Labor has set out, and the employer has to agree to pay the prevailing wage for the position. So these are all components of the labor certification process. I will say that the labor certification process is the most common way for individuals to secure permanent residence based on employment. But it is also a very labor intensive process, and it is very lengthy. I will tell you, just for the first step of the process, the filing of the labor certification with Department of Labor, they are currently taking 495 days just to process that first step. So it is a lengthy process, but as I mentioned, this is probably the most common pathway to permanent residence. All right, I've been doing a lot of talking, and I see that there are lots of questions in the chat. And so let's see if we can maybe now turn to some of those questions. So it looks like we have 10 open questions. So maybe I'll just start reading through those and we can talk through them. And so the first question is whether and how the government shutdown influences the H-1B petition. Fantastic question. It does impact the H-1B petition. And here is how it impacts. So as I mentioned, one of the components of the H-1B petition is the filing of a labor condition application, an LCA, where the company agrees to pay the prevailing wage for the position. That gets filed with Department of Labor. They certify it. Normally, that takes 7 days. With the government shutdown, Department of Labor is not operational. They are not doing anything. So we cannot get LCAs certified from Department of Labor. We cannot file the H-1B petition with the Immigration Service unless we have that certified LCA. So what we have been told by in prior years that we have had government shutdowns, in prior years, USCIS, U.S. Citizenship and Immigration Services, has excused filing delays due to the government shutdown. USCIS is operational. And that is because they are a fee-based organization. So they are still getting money coming in. Department of Labor is not fee-based. So they are not operational. So we are still filing H-1B cases for situations where we have secured the LCA before the government shutdown. But for cases where we need that LCA, we cannot move forward until the government shutdown ends. Okay. Let's see this next question. If the H-1B petition is not approved before the expiration of a STEM OPT EAD, am I allowed to lawfully stay in the US and wait for the approval to start working? So this is obviously a case-specific question, and so I don't want to necessarily get too much into the details, but I will say when a change of status is timely filed, an individual is allowed to remain in the United States until that petition is adjudicated, and we'll kind of leave it at that. But any type of specifics you obviously want to discuss with the legal counsel that filed the H petition. Okay, now the next question is for the national interest waiver, does a master's in oceanography with a focus on acoustic work, if it could have the application for national defense? I'm currently on an F1 and applied for an EAD. So obviously we would need to know more details. Does it have an impact on national defense? Can you get letters attesting to the impact it will have on national defense. A lot of this is in the details. So we want to know what can you prove? Can you get a letter from the Department of Defense saying that the work you are doing is in the national interest? Can you get other experts to attest to something similar like that? So those are the things that we would look at to see whether a national interest waiver makes sense. All right, the next question is, given the let me see here, given the varying processing times for EB2, if I change the job along the pending I-14485, will this impact the application due to the endeavor change? All right, so again, a lot of this is going to be in the details. So if the EB2 is labor certification based, then and the I-140 is still pending, you have an issue. Changing jobs will impact the viability of that green card case, because the green card process is also employer specific. If you have a self-petitioned EB2 petition, then changing employers is not going to impact your green card case, as long as the work you are doing continues to be in the national interest of the United States. So let's see the next question here. If I change my status from J to H within the US and I need to travel outside the US, do I still need to pay the $100,000 fee when I apply for the visa stamp? So this was an open question for us after the presidential proclamation, but just this week we received clarity, and they have told us if you change your status inside the United States, you get that H approval, and then you later travel and you apply for the visa stamp, you are not going to be hit with the $100,000 fee. That fee only gets paid to USCIS with the petition that is filed with the USCIS. It does not get paid to the US consulate. Okay. Next question, is the harder approval only with regards to petitions of NIW or for adjustment of status after the NIW is approved? So the real scrutiny that we are seeing is with the adjudication of the national interest waiver. The adjustment of status process, what they are looking for in that stage is whether there is anything in your background which would prohibit you from getting a green card. So are there any immigration violations? Do you have a communicable disease? Are you on the terrorist watch list? Are you a member of the Communist Party, etc.? So assuming that you don't have any of those things, the green card should be approved, assuming that the national interest waiver has been approved. Okay. Next question is, I heard from a friend that the NIW rules are going to change in January and it'll be harder to get one. Is that true? So the short answer is yes, it is true. What has been released, every year we get the regulatory agenda for the year that the government puts out. And so in the regulatory agenda that has just been released, they want to make changes to make it harder to secure EB1 cases, national interest cases, and O1s. So those processes, once the regulatory change goes into effect, is going to make it more challenging to get those cases approved. Now, I don't know I wish I knew what changes they're going to put into place. I don't know that, but I do know that they have their eye on those categories and they want to tighten those categories up with regards to adjudications. Okay, next question is, how do I determine if I'm eligible to start the green card process? This person got their bachelor's on an F1, worked as a researcher for 3 years, and now they're a J1 research scholar. How do I determine if I can become a permanent resident? So if you're going through a pathway that requires employer sponsorship, so outstanding researcher or labor certification process, you need to have the conversation with the employer to see, are they willing to sponsor you? Some employers have certain periods of employment before they will consider green card sponsorship. If you are looking at a self-petitioned option, extraordinary ability, national interest waiver, you want to obviously read through the criteria. If you believe you meet that criteria, then you want to set up a consultation with an immigration attorney, have them review it with you to say, this seems to be a viable case, or not quite yet. You should try to strengthen your case by doing X, Y, and Z. So that's really my advice. If it's through an employer, have the conversation with the employer. If it's self-petitioned, look at the categories and then set up a consultation with an immigration counsel to discuss. All right. If I apply for H-1B change of status from F1 right now within the US and don't plan to leave the US while waiting for the approval, is there any possibility that I can be subject to the fee? There is a possibility. The possibility is if the immigration service determines that you did not maintain your F1 status, they could then, instead of approving the case as a change of status, they would approve the case for counselor notification, and they would then at that point require the $100,000 fee. But if there is no status violation, then there really isn't a possibility of that $100,000 fee kicking in. And so again, just really stressing, if you get the H approved through change of status and then you travel, that is not an issue. No $100,000 fee, okay? We have about 5 more minutes. Let's see how many other questions I can get through. So for this question, for the EB category, is the number of available positions assigned to Great Britain as a whole, or is it separated, like Scotland, England are assigned separately? So I believe the classification is UK is how they separate it. So there is one allotment to the UK. So hopefully that answers your question. Let's see, the next one is, I'm on a J1 and my last date is December 5th. I have an offer for an H-1B, shutdown is going on, you're not able to get the LCA, not able to file the H-1B on time. What will happen? Are any other possibilities to make legal status? So obviously, you want to be in communication with the H-1B employer and their legal counsel to discuss those options. You know, as I mentioned in prior shutdowns, they did excuse late filings due to the shutdown. But in this scenario, I would strongly just encourage you to get in contact with the H-1B employer and their legal counsel to discuss, you know, those options. When will the new regulatory changes be in effect? Great question. I don't know. But the way that the regulatory process is supposed to work is they issue a proposed rule, then they give a period of time for comments, and then they review the comments, and then the rule should go into effect. That's how it should happen. We will see. But unfortunately, I don't know beyond that to give any type of specificity. All right. After changing from J1 to H1B in the US and it gets approved, and then I travel to India and I need a visa in my passport, in this case, no trigger to the 100K. Again, if you get the H1B approved as a change of status in the United States, and then you later travel and you go to the consulate, no $100,000 fee. The $100,000 fee only applies if you're outside of the US when the petition is filed, adjudicated, or it is determined that you were not maintaining status when you filed as a change of status. Okay. Next question. Can I travel in OPT, but filing the H-1B request inside the US without paying the fee, or am I supposed to remain in the US and file? You're supposed to remain in the US. Given the government shutdown, will my OPT application be processed if I apply right now? Yes, it should be. USCIS is operational. They are still processing cases because they are fee-based. It's just Department of Labor that is being impacted by the shutdown. USCIS is not being impacted. They are still operational. They are still adjudicating cases. All right, with that, I will give it back to you, Sandra. Thank you all so much. It's been a pleasure talking with you all. Some really fabulous questions.
Thank you, Diana. We appreciate this. And for everyone, we will be posting the presentation on our website, so look out for that. Thank you, everyone, for coming. Thank you,
Take care,
Diana.
everyone. Absolutely.